before enumerating the various types of fundamental rights, right? Article 14, 15, 16, 17, 18, which deals with equality. Similarly, 19 to 22, which deals with right to freedom. 23, 24, right against exploitation. 25 to 28, freedom of religion. 29 and 30, cultural and educational rights. Before they went about defining each of the rights, enumerating each of the rights under these various articles, just to show the importance of fundamental rights, they first, immediately after defining the state, put restrictions on the state. If you go and read your NCERT textbook, Indian Constitution at Work or Political Theory, right, both important reads for the UPSC exam, class 11 textbook, it will say what are the functions that a constitution performs. And one of the functions of the constitution, which is an important function, is placing restrictions on the state on what it can or what it cannot do to its citizens. Right? So, the fundamental rights primarily place restrictions on the state and tries to give liberty and equality to every individual person and citizen in this country. So, to bring out this importance, immediately after defining the state, Article 13 tries to put restrictions on the state, and it says, if you make a law which is inconsistent, which violates, which is not in line with the fundamental rights which are listed in this part, then to the extent of that inconsistency, to the extent of that violation, that law will not be enforceable. It will be void. It will not be valid. So that is before even enumerating the rights, they immediately tell, after defining the state, they tell the state, look, legislature and executive, government of India and Parliament of India, look, government of a state and state legislature, look, local authorities, you are all state for the purposes of this part, and that is what is given in Article 12, and in Article 13, they are trying to tell the state, look at the state, if you take away any of the fundamental rights that the Constitution gives from 14 to 32, then that law is not valid. Right? So that is the importance of Article 13. It is one of the basic articles which gives the scope for judicial review, because the Constitution says any law which takes away the fundamental rights is void under Article 13, and who will decide? The legislature or the executive cannot decide, because they are the ones who make the law. People cannot decide. So who will decide? The courts will decide whether a law is inconsistent or violative of the fundamental rights. Right? So with that background, let's look at what Article 13 says. Article 13 says, all laws in force in territory of India immediately before the commencement of this Constitution, insofar as they are inconsistent with the provisions of this part, shall to the extent of inconsistency be void. What is the meaning of the term void? Void in simple terms means not enforceable. It is not valid. You cannot take it to a court and enforce it. That is the definition of the meaning. That is the meaning of the legal word called void. Right? So what does it say? Any law. We have so many laws which are continuing. Our basic criminal law, the Indian Penal Code itself is from 1860. But if any of the sections of Indian Penal Code is violative of the fundamental right, that can be declared by the courts as void. Recent example, classic example is section 377, which criminalized homosexuality. But now in 2018, the court said, no, this is violative of the fundamental right of privacy, and so they struck it down. Where did the court get the power to strike down section 377 of the Indian Penal Code, which was enacted in 1860? By virtue of Article 13(1). Because it says, all laws which are there in force even before the commencement of the Constitution, if they are inconsistent with any of the provisions of this part, then to the extent of that inconsistency, they can be declared void. So it's not necessarily that automatically they will become void. Some of them would have automatically become void, but some of them may be challenged in a court, and it took almost 68 years after the Constitution commenced to declare section 377 or section 497 or 498, which deals with adultery law, to be declared as void. But it's a continuous process. So that's why the Constitution is a living document. It is subject to interpretations and reinterpretations by the Supreme Court and other courts of this country. But this is the first point. And secondly, it also says the state. What is the definition of the state? We just saw. Be it center, be it state, be it local authority. The state shall not make any law which takes away or abridges. Abridges means what? It restricts the rights conferred by this part, and any law made in contravention of this clause shall to the contravention be void. So whatever is there before the commencement of the constitution, they will be void. And after the constitution commences, the state should not make a law which violates the fundamental rights. So that is the importance of fundamental rights, right? It places restrictions on the state. And if the state makes any law which takes away your fundamental rights, or does any action which takes away your fundamental rights, what can you do? You can directly approach the Supreme Court of India under Article 32. Right, guys? So that is with respect to Article 13. It goes on to define, in this article, unless the context otherwise requires, a law includes an ordinance, an order, a bylaw, a rule, a regulation. So it's not just a law, a simple law which is passed by the parliament or the state legislature. That is what we all understand. Law in our mind always means an act, right? Right to Information Act, Aadhaar Act, Constitutional Amendment Act, Triple Talaq Act. So all these are laws which are passed. So it is not just the law, the act which is passed by parliament and state legislature which is a law for the purpose of meaning Article 13. Why? Because state does not include only the legislature. It includes even the executive. Executive means what? Government. So what will government pass? Government will put a GO, right? We have all heard of the term GO, government order. They will put an ordinance. They will put a notification. They will put a rule. They will put a regulation. All that. Everything is a law within the meaning of this article, which means what? None of this, be it an act passed by parliament or state legislature, be it an ordinance or rule or regulation or order which is passed by government of India or government of any of the states in India or any local authority in India, none of that can violate your fundamental rights. And if they do violate, the courts have the right to strike it down as unconstitutional. And finally, Article 13(4). Now, this is something which you will understand better when we discuss it along with the amendment to the Constitution, right? So you can just park it for the time being. We will discuss this along with the amendment to the Constitution under Article 368. That is when you will understand the basic reason, because this was something which was added in 1971. So we will keep this aside for the time being, but I'll explain it to you in a subsequent session. Right, so basically, so what have we learned till now under the basic philosophies of fundamental rights? So rights to begin with. What are rights? Rights are nothing but claims. Of whom? Of citizens. Against whom? Against the state. Now, what are the various types of rights? You can have natural rights. Those are life and liberty. In India, the natural rights are subsumed under fundamental rights. They are very much part of fundamental rights. So what are fundamental rights? They are basic rights of liberty and equality, which is enshrined in the preamble to our Constitution. They are enumerated and guaranteed in Part 3 of the Indian Constitution. You have constitutional rights which are outside of Part 3 but which are nonetheless very important and provided in the Constitution. And then you have legal rights which are provided through statutes, which means what? Laws made by Parliament or state legislature. So now fundamental rights, coming to fundamental rights, they are basic rights, liberty and equality, which are given, which are the claims relating to that of the citizens against the state. So Part 3 of the Indian Constitution starts with the definition of the state. It says who is a state, and it further goes on to say that state cannot take away the fundamental rights which are enshrined, which are guaranteed in Part 3 of the Constitution. And then, so that is, guys, the basic understanding of fundamental rights. Now in the subsequent sessions, we will try and understand every type of fundamental right. What is right to equality? Article 14 to 18. Right to freedom? 19 to 22. Right against exploitation? 23 and 24. Freedom of religion? 25 to 28. Cultural and educational rights? 29 and 30. These reflect the equality and liberty which is given in the preamble. And we will try and understand each of these articles. Right. So to sum up, conceptual points relating to fundamental rights. Rights are effective restrictions on the state against individual liberties, because we are a democratic country. We believe in the liberty and equality of every individual. That is why we fought for, and that is what we have guaranteed to every citizen and every person living in this country, that we will give you liberty, we will give you equality. So they cannot be taken away by the state. State means what? Either the government or the legislature at the center, or at the state, or even the local authority. They should not take it away in an unreasonable way. So fundamental rights are effective restrictions on the state. Fundamental rights are correlative with duties, though duties are not enforceable in a court of law, but they are correlative, right? Duties have been added in 1976. We'll have a separate session on fundamental duties separately in a subsequent session, and that time you'll understand that the fundamental duties were added subsequently in 1976 just to make them correlative with rights. However, rights are enforceable, duties are not enforceable by the state. So that basic understanding and difference we must understand. And finally, rights are nothing but claims of citizens against the state. While ordinary legal rights are protected and enforced by law, fundamental rights are protected and guaranteed by the Constitution itself. Right? So I hope you understood the basic characteristics or basic features of fundamental rights. What do you mean by fundamental rights? What is the essence of fundamental rights? How is it linked to the preamble? What are the conceptual points relating to fundamental rights? What are the various types of rights which are enumerated and guaranteed under Part 3 of the Constitution? So these are the things that we have covered in this session, and I'll see you again in the next session, where we'll be discussing about individual types of rights, right to equality, right to freedom, so on and so forth. So I hope you found this online session useful. So we'll be continuing to engage through the online manner like this. Thanks for watching. Good luck.